Somewhere in Alabama right now, a family is sitting around a table, trying to make sense of something that does not add up. A parent who spent decades saying to their kids that their estate was going to them, but then signed a new will in the final weeks of their life. If that story sounds familiar, what you may be dealing with could be undue influence. And Alabama law has a process for addressing it. I am Asthana at Southern Estate Lawyers, and we represent families who believe that their loved one was manipulated to change their estate plan. And we represent people who are being accused of that and need a defense. Let's start with what undue influence actually means, because a lot of people confuse it with just ordinary family pressure. It's perfectly legal for a family member to say, "Mom, leave the house to me." That's normal, that's persuasion. But undue influence is something different. It happens when someone uses a position of trust or dependency to override another person's free will, to push them into making decisions that are not truly their own. Alabama courts have described it as influence that causes a person to make a disposition of their property, contrary to their own free will and desires. The person may be signing a document, but what ends up in the document reflects someone else's wishes, not theirs. And this happens in predictable patterns. A caregiver who was a stranger 6 months ago is now the sole beneficiary of someone's estate and holds power of attorney over every account. A dying sibling who spent years saying that the estate would go to family suddenly changes everything and gives it to a friend 2 months before they pass. An elderly mother, terrified of being put in a nursing home, changes her estate plan after one side of the family uses that fear to influence her, isolating her, controlling her decisions, driving her to the attorney's office. We have litigated every one of these fact patterns, and in every one of these situations, the same question eventually gets asked. Was this really what the person wanted, or did someone else make this happen? Under Alabama law, proving undue influence does not mean that you have to prove it beyond reasonable doubt. There's a specific legal framework for it. Alabama courts require three things. First, a confidential relationship. That means a close bond where one person trusted and depended on another. A caregiver, a child, a romantic partner, a close friend who became a primary source of support. Second is a dominant and controlling influence, not just closeness. Actual control over the person's daily life, who they saw, what decisions got made, and whether they could speak freely to anyone else. Third is undue activity in procuring the document, the trust, the will, or the amendment. This is where the manipulation becomes visible. Did that manipulator call the attorney? Were they present when the attorney meeting happened? Did they drive them there? Did they sit in the room directing what the document should say? Did they pay for the document? When you can show all these three requirements, Alabama law creates a presumption of undue influence. The burden then shifts, and the other side has to show that that didn't happen. Undue influence often does not stand alone. If the person who signed the new estate planning document was suffering from dementia, stroke, severe medication effects, or cognitive decline, that is a separate legal claim called mental incompetence. A person can physically sign a legal document and still lack the legal capacity to understand what it means, what property they're disposing of, or who the beneficiaries actually are. In Alabama, undue influence and mental incapacity, also referred to as mental incompetence, are often argued together. Because the lower someone's capacity, the easier it is for someone else to step in and unduly influence them and substitute their wishes with the manipulator's wishes. So what legal instruments can actually be challenged? Wills are most common. If undue influence caused a will to be created or changed, depending on the county, the will can be contested in Alabama probate courts or circuit courts. Trusts face the same standard. Under the Alabama Trust Code, a trust is void to the extent its creation or amendment was induced by fraud, duress, or undue influence. Deeds and lifetime property transfers can also be challenged. If someone was manipulated into signing over a house, a piece of land, or financial account while the person was still alive, those transfers can also be voided. Powers of attorney are another path. If someone was manipulated in naming the wrong agent, and that agent then uses their authority to change accounts or move money, that too can be challenged. If the court finds that undue influence in fact occurred, the results are real. The affected will, the trust, amendment, The deed can all be voided, set aside entirely. If there was an earlier estate plan that wasn't tainted, the court will restore that. The assets go where they were always intended to go. If no prior documents exist, Alabama's intestate succession laws take over, and the estate passes to the closest family members by law. For trusts and property transfers, courts can also trace and recover assets that were taken during that person's lifetime and return them to the estate. Now, there is another side to this. Not every accusation of undue influence is true. Sometimes a family member who was simply close to a loved one, who showed up, who helped, who stayed, gets accused of manipulation by relatives who weren't there. Sometimes the person who is genuinely loved by the deceased receives an inheritance that other family members did not expect, and they are aggrieved and file a lawsuit. An accusation is not proof. Under Alabama law, there must be substantial evidence of a dominant and controlling influence and actual undue activity in the procurement of the legal instrument. A close relationship is not enough. Receiving a large inheritance is not enough. If you are being accused of undue influence and you cared for the deceased honestly, and the changes to the estate plan reflect the true wishes of the decedent, you deserve a lawyer who can build that defense and take you to trial if necessary. We have done exactly that. As Southern estate lawyers, we have litigated both sides of these types of cases across Alabama, in Baldwin, Mobile, Jefferson, and Shelby counties, and throughout the state. We delivered a $3 million result for a sister whose inheritance was significantly reduced by the undue influence of their sibling applied to their parent, or the parent's medical records showed an altered mental status and onset of dementia. We obtained an $800,000 settlement for a client whose inheritance was lost completely when a trust was amended because a non-relative caregiver suddenly moved in and exerted undue influence. And we have successfully defended clients who were accused of manipulation and protected their inheritance, most recently securing a $2.5 million settlement in a will contest where the beneficiary was accused of undue influence. These cases are won by lawyers who understand the evidence, know Alabama case law, and are willing to take the case all the way to trial. And that is what we do. If you believe that a loved one's estate plan was wrongfully changed, the timing matters, and the deadlines are different depending on what was changed. For a will, Alabama law gives you 180 days from the date that the will was admitted into probate to bring a contest. Not 180 days from when you found out, but 180 days from the date that the probate court accepted it into probate. And that clock starts whether you were aware or not. For a trust, the deadline depends on what notice you received. If the trustee formally notified you of the trust's existence, you have 6 months from that notice to challenge it. If you never received that formal notice, Alabama gives you up to 2 years from the date of the settlor's death. That's the person who created the trust. For lifetime transfers, a deed that someone signed over, a bank account that was changed, property that was transferred while they were still alive, the deadline is generally 2 years. But when it comes to fraud, Alabama's discovery rule will apply, meaning the clock may not start to run until you actually discovered what happened or should have discovered what happened. In every one of these situations, the evidence starts to disappear quickly, long before the deadline arrives. So don't wait for the deadline. The sooner you act, the more evidence you have to work with. So what does challenging a legal instrument actually cost? The honest answer is that undue influence cases, just like most estate litigation cases, can be financially unpredictable. So, as Southern estate lawyers, we offer flexible fee arrangements. Depending on your case, we may work on a retainer with the remainder on a contingency fee, a retainer billed at our hourly rate, or in some cases, a full contingency fee arrangement. Every case is different, and we walk you through all these options at the very beginning during our free consultation. That way, you know exactly what to expect before you commit to anything. If your loved one's estate plan was rewritten by someone else who moved into a position of trust when your loved one was most vulnerable, we want to hear from you. And if you are being wrongfully accused, where you actually genuinely cared for someone and now it's being used against you, we want to hear from you as well. Call Southern Estate Lawyers for a free consultation. We will go through the facts with you thoroughly, and if you have a case, we will fight fiercely to protect your fair share. We look forward to working for you.